Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. 2025 is upon us. And well, I'm blessed to receive regular thoughts from the immigration god himself, Ira Kervishnu to some, Ira of Nazareth to others, and Ira Kurzban to most. One of Ira's updates this week notes, among other things, key immigration cases to watch in 2025. To Ira, some of the quite interesting cases implicate the inherent conflict between the Supremacy Clause and whether incoming President Trump will support the federal government's power over the power of Texas and Florida and other states to decide immigration issues, and ultimately other issues regarding federalism. Another major case on the docket is the Riley case, where the Supreme Court will decide when the 30 days run for an appeal, where there has been a withholding-only proceeding following reinstatement of a final order of removal. That naughty issue discussed many times on the pod last year. Is it 30 days from the removal finding or 30 days from the withholding or Convention Against Torture denial? That usually comes months, if not years, after the administrative or immigration judge order of removal. We shall see. Ira also highlights how the Sixth Circuit recently overturned net neutrality in a case that relied heavily on the Loper-Bright decision from the Supreme Court and may have come out differently if Chevron deference was still a thing. The Sixth Circuit cast aside the FCC determination on net neutrality despite similar deference apparently in the past, in a decision that's pretty scary if you support net neutrality. Loper-Bright will be shaping our country probably for the remainder of my career. Embrace it. 2 cases this week after a heavy end to 2024. Rejoice! Or don't, but do listen. I beg you. Are you struggling to find and hire new talent that you can trust? Does the idea of onboarding, training, and managing virtual staff overwhelm you? Staffy's got your back. Staffy provides top-quality virtual staffing for immigration law firms, complete with HR support to free up your time from the hassles of onboarding, managing, and continuously training your virtual staff. With an entire team of professionals, including psychologists and mindset, task, and performance coaches, Staffy ensures your virtual staff has all the tools needed to help your law firm grow and scale. Visit staffy.cc, that's stafi.cc, and schedule a consultation to claim $500 off your first month of service. Or, of course, click on the link in the show notes. You're probably hearing a lot of buzz about how law firms are starting to use artificial intelligence. And well, I recently had the opportunity to talk to the folks at Serenade about their case management system, e-immigration. They've been making software for immigration attorneys longer than anyone else. And they're doing some pretty cool stuff with AI. They have a suite of tools that they're calling AI Workmates. That sounds like it's got huge time-saving potential. One of their tools even lets you upload a PDF and instantly creates a client profile. There's another tool that can read content on the website and instantly summarize it, which is pretty helpful when referencing historical case rulings or, dare I say, country condition evidence. They've got some other tools too scheduled for release later this year. So if you're trying to wrap your head around how to use AI in your practice, I encourage you to have a chat with the folks at Serenade. Also, check out their blog at serenade.com/blog for their recent articles on AI in legal practices. Or, of course, click on the link in the show notes. Our first case is United States v. Defrance, published by the Ninth Circuit on December 30th, 2024. It is officially the last decision of 2024. For our purposes, this case is about crimes of violence. Mr. Defrance was convicted in federal district court of having violated 18 U.S.C. section 922 G9, which forbids the possession of firearms by anyone convicted of a, quote, misdemeanor crime of domestic violence, end quote. Thank Ira Vishnu, the Supreme Court recently held that criminalizing such things is sufficiently within the scope of our country's history and tradition a la Bruin. Debatable, to be honest. But still, was Mr. Defrance properly convicted in the first place? His predicate offense, a conviction that occurred many years before the firearm violation, was for assaulting his girlfriend in violation of Montana Code annotated section 45-5-2061A, a misdemeanor. Is that conviction a crime of violence, such that it's a crime of domestic violence, such that Mr. Defrance can now be convicted for the firearm thing? It is not, explained the Ninth Circuit. Categorical approach applies, and the definition of a crime of violence for this offense is the same as the immigration definition. To qualify, the Montana crime must have, quote, as an element, the use or attempted use of physical force, end quote. That Montana offense in turn reads that, quote, a person commits the offense of partner or family member assault if the person purposely or knowingly causes bodily injury to a partner or family member, end quote. Seems like a categorical match to me at first, except this. Montana's statute makes clear that, quote, bodily injury means physical pain, illness, or an impairment of physical condition and includes mental illness or impairment, end quote. Of course, under the categorical approach, it's the statutory elements that count, not what the individual actually did. Kinda straightforward then, actually. Quote, both Ninth Circuit case law construing this statute and Montana Supreme Court decisions construing related assault statutes support Mr. Defrance's contention that section 45-5-2061A does not have as an element the use or attempted use of physical force, end quote. Verbal conduct alone, for example, can result in a conviction, at least when it results in, quote, subjecting someone to a public tirade of insults or emotional abuse, end quote. Not something to strive for in any relationship, but it can get you convicted of a misdemeanor in Montana. And is it violent? It's not. In another Montana case, for example, and I kid you not, it involved a defendant who, quote, posing as a doctor, telephoned a woman and convinced her to cut off her nipple, end quote. Also not violent, at least not directly from the defendant who's just talking on the phone. And look, the Ninth Circuit went there, so who am I not to? As I so often mention, Montana's decision to criminalize the actions of more people has resulted in Montana writing a statute so broad that it's not necessarily violent. And that means that people who are convicted of it cannot later have their sentences enhanced, be deemed aggravated felons, or here, be convicted for possessing firearms. Reason the Ninth Circuit in this holding. Flat out, quote, conventional wisdom is that bodily injury does not include pure mental injury, end quote. I wonder what other states criminalize that phrase, that is bodily injury, even if not expressly statutorily defined, like it is in Montana. Careful with this argument though, footnote 5 pours some cold water on it, but still, it's there. Have your antenna up when your statute criminalizes bodily injury. Having so held, the Ninth Circuit explained, no government, Mr. Defrance need not find a case and satisfy the realistic probability test to show that Montana actually prosecutes this specific statute in an overbroad manner, where the statutory text alone or state case law interpreting that or similar texts makes quite clear that Montana criminalizes more than violent force. Stop trying to make bad law, government, on the realistic probability test. You know that's not how it works in the Ninth Circuit. Rather, the way the realistic probability test is supposed to work is as a benefit to the non-citizen or criminal defendants. Quote, where a statute's overbreadth is not evident from its text, a defendant can show the requisite realistic probability of prosecution for conduct that falls outside the generic definition by pointing to his own case or other cases in which the state courts, in fact, did apply the statute in the special, non-generic manner for which he argues. End quote. That's it. It's not a sword for the government. It is true, explained the Ninth Circuit, that while it's technically possible to convict someone for non-physical actions under this Montana statute, there was no example of that happening, that is, the prosecution. And such conduct would likely actually be punished under a different Montana statute. Doesn't matter, though. That's not how the categorical approach works. The statute uses, quote, bodily injury, end quote, and that has an expansive, overbroad meaning in Montana. Case closed. Mr. Defrance's firearm conviction, premised on the misdemeanor crime of domestic violence, is vacated. Both separately concurring. Neither Judge Christian nor District Court Judge Rakoff, sitting by designation, seem thrilled with the categorical approach, but the law is the law. Both of them recognize. And that is United States v. Defrance. Final case, then, is Zarzecki v. Garland, published by the Seventh Circuit on January 3rd, 2025. The first official case of 2025. This case is about adjustment of status and jurisdiction. Miss Zarzecki is from Poland and came to the United States on a tourist visa in 1989. She's remained here ever since and married her husband in 1998, who at some point naturalized to U.S. citizenship. Their 19-year-old daughter is a U.S. citizen, too. Because she entered lawfully, she was eligible to adjust to lawful permanent resident status once her husband naturalized, and she went for it in 2012 or 2013, unclear. But USCIS denied, and DHS initiated removal proceedings. The reason USCIS denied, it seems, is 8 or so years before she applied, Ms. Zarzecki became drunk while working at a home where she was a caregiver, drove home quite fast and drunk over the speed limit, and struck a car from behind, killing the driver and severely injuring the driver's husband. Ms. Zarzecki received a plea deal to felony aggravated DUI, received a 9-year prison sentence, and served about 8 years of it. Tragic. So I guess USCIS denied as a matter of discretion, and when Ms. Zarzecki renewed her application in immigration court, an immigration judge denied too. Plus, Ms. Zarzecki had 2 other arrests that did not result in conviction. But on the other hand, that is for the discretionary analysis, Ms. Zarzecki testified that she suffers from depression and had used medications in the past, but sometimes used alcohol to cope, and that she even became suicidal without treatment. I imagine she didn't make that argument as an excuse, but just to contextualize. She submitted some evidence of these mental health difficulties. On the other hand, Ms. Zarzecki testified that she didn't attend therapy or treatment groups while in prison, and that once on the outside, quote, alcohol treatment would inconvenience her husband or daughter, who would have to drive her to the meetings, end quote. Anyway, considering all of this, including the hardship to Ms. Zarzecki and her daughter and husband if she had to return to Poland, the immigration judge denied, seemingly as a matter of discretion, as adjustment of status is always discretionary relief. Exercising its de novo review of discretionary findings as the regulations mandate, the BIA affirmed. While I bet the BIA didn't do so as thoroughly as the IJ, given that the BIA is an appellate body, the BIA appears to have weighed factors in its discretionary analysis. Relief denied and removal to Poland a real possibility, Ms. Zarzecki brought her case to the Seventh Circuit, which held that, well, it couldn't really review any of it. Remember the context that we're in, my friends. INA Section 242A2BI expressly lists adjustment of status as the type of discretionary relief that circuits may not be able to review. And the Supreme Court interpreted that limitation very, very broadly in Patel. Circuits retain jurisdiction to review questions of law, that's INA Section 242A2D. And so, that's the type of argument that Ms. Zarzecki brought. Kind of. She argued that the BIA failed to properly consider expert medical evidence regarding her mental health. And quote, she is correct that the wholesale failure to consider evidence would constitute an error of law, in the sense that it would demonstrate a failure to exercise discretion at all, end quote. Remember that one. That is, even though it's ultimately a discretionary analysis, the complete ignoring of evidence is a legal error that circuits can review. Quote, a wholesale dereliction of duties to consider the evidence amounts to a reviewable legal error, end quote. That's just not what the Seventh Circuit saw here. And even Ms. Zarzecki wasn't arguing that the agency completely excluded the evidence. She appeared to take issue with the weight given to that evidence, that is, of her mental health condition, and how much the agency, that is the BIA, really considered the evidence given the fact that maybe it wasn't discussed as much as Ms. Zarzecki believed it should have been in the decisions. To the Seventh Circuit, quote, these are complaints about the depth and weight the agency gave to the evidence and testimony. The balancing of evidence, however, is at the very core of the discretionary authority of the agency over which we lack jurisdiction, end quote. The BIA need not thoroughly discuss every single piece of evidence to do its job, explained the court. It can't disregard it, but it need not write the best decision in the world. More fundamentally here, explained the Seventh Circuit, quote, it is not clear to what expert testimony Ms. Zarzecki is referring, end quote. There were no expert reports in the record, explained the court. Pretty scant evidence, actually, the Seventh Circuit seems to believe. Learn how to submit and use expert evidence, my colleagues. It can be powerful stuff. Especially if you're arguing the failure to consider it on petition for review. The agency did adequately consider Ms. Zarzecki's own testimony about her mental health, which of course is not expert evidence, but it's still evidence that needs to be considered, explained the Seventh Circuit. But considered it was, even some of the uncorroborated stuff. Reading between the lines, fairly or not, the Seventh Circuit doesn't seem overly impressed with many of the arguments being made by Ms. Zarzecki on petition for review, and seems a bit perplexed at the arguments. Perhaps that and the serious conviction affected the Seventh Circuit judges. Judges are, after all, people too. Ms. Zarzecki, for her part, lost her case. And that is Zarzecki v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to, from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.